Hello, I'm Peggy Hora. I'm a retired judge from California, and I am president of Justice Speakers Institute. It's my pleasure to have one of my partners with me here today. We're going to talk about some interesting voting rights cases. Brian?
And I'm Brian McKenzie. I am, as Peggy says, a partner in the Justice Speakers Institute. And we spent some time last evening sort of going over the really interesting events of this past week in terms of Voting Rights Act. And Peggy suggested that we do a little conversation on it, and I thought that was a great idea.
Well, we seem to be just now after 2 weeks of conventions from both parties. We're less than 100 days from the election. All of these cases, all of a sudden, have come up in the last 2 weeks, 5 cases on the Voting Rights Act. We know it took blood, sweat, tears, and death to get the passage of the Voting Rights Act in 1964. And these are almost, it seems to me, a second visit to that time in many ways, that there's more going on and more sort of nefarious shenanigans on the part of legislatures to deny people the right to vote. So what's your overall take on that?
Well, the United States Supreme Court a few years back made a major change in the Voting Rights Act by getting rid of pre-clearance in a case called Shelby County versus Holder. And basically the Supreme Court said there's no longer any evidence that there's sufficient racial animus in our country to continue with the pre-clearance requirement of the Voting Rights Act. And almost instantly after that, a number of legislatures began passing laws that changed voting requirements. Mm-hmm. And the impact of those changes had to work its way through the courts. And at different speeds in different locations.
Yes. And
different legislators acting slower or faster. And the result is that a number of those changes, and particularly in Texas and North Carolina, those changes were very quickly made, have now worked their way through the district courts into the Court of Appeals, and in some cases have worked their way into the district courts. And as it happens, all of these post-Shelby County cases are just coming to the fore right now because we have an election coming up.
Right. And it's going to make a huge difference potentially in who wins the election based upon who's able to vote.
That's true.
You know,
and all of the decisions that came out were on pieces of legislation in the different states that restricted access to the poll.
Exactly.
And all of them were challenged on the basis of those restrictions, most on the basis of a claim of denying a particular group, African American or Hispanic, access to the polls.
And that's such a cornerstone of our democracy, that the right to vote, one person, one vote, you know, the idea that we had to have constitutional amendments to allow African Americans to vote, to allow women to vote. Voting is just such a basic part of our being. The fact that these legislatures would try to deny access like that is just shocking.
Yeah, and the basis for all of these legislative actions is a claim of we're going to prevent voter fraud. And particularly in the Fourth Circuit decision, the court said that that was a solution in search of a problem, that there was no evidence whatsoever that there had ever been the sort of voting activity, which is to say going in and claiming that you're another person when you go to vote, in North Carolina ever. There wasn't a single incident of it. And the result is you're preventing a large number of people from voting in order to stop a problem that states never had.
Exactly.
And the court found that to be highly suspect in light of everything else that went on in the legislative approach to this.
Now, you talked about the Fourth Circuit. Tell me exactly what a circuit court is. Tell me what an appellate court is versus the district and trial court. Give us a little background on who's making these decisions.
Well, most people, I think, are aware that in the United States there are two types of courts. There are state courts, those that are under state constitutions, they're state governmental bodies. And then there are federal courts. Federal courts were created by the Congress to handle federal issues, federal laws, and really to do a lot of the constitutional heavy lifting. And so as time passed and the country expanded, they kept adding appellate circuits and district circuits. Yeah. So most states will have, well, and for instance, in Michigan, we have two different federal courts. We have the Eastern District and the Western District, and that covers the entire state of Michigan. I don't know what they have in California. What is it, 2?
No, we just have the Ninth Circuit that's always getting in trouble with everybody
the
else.
district level.
Oh, no, we have Central, Northern, and Southern.
Yeah, and so we have a limited number of federal courts in each state. And after the trial level federal court hears it, it goes up to an appellate level. And in your case, it's the Ninth Circuit. In the case of Michigan, it's the Sixth Circuit, which takes in an area of the upper Midwest. And in the case of the North Carolina decision, it's the Fourth Circuit, which takes in an area of the southeastern portion of the United States.
And that's where the case that had the very long opinion and, you know, the other things we'll talk about in a minute, that's where it came out of.
That's correct. North Carolina is in the Fourth Circuit, whereas the other opinion, the other major contrasting opinion came out of the Fifth Circuit, which includes Louisiana and Texas and other states in south central United States.
Okay. So we get all that now. So how is it that a court can tell the legislature that their law is bad?
Well, that's because we're a democratic republic. The United States is the oldest democracy in the world, which in many ways makes it the most conservative democracy in the world. And the founders had a concern that the decision of the majority could not take away the rights of the minority. And so they put in place what we know as checks and balances. They first checked and balanced the government. They gave presidential checks and balances, congressional checks and balances, and the courts checks and balances. But in addition to that, they implemented, of course, what we know as the Bill of Rights, and subsequent amendments there too. And those place further checks and balances on the system. And what we basically say is the majority rules except when it takes away the rights of the minority.
Right.
And under the checks and balances that our system has set forth, if you believe your rights have been impinged, the ultimate arbiter of constitutional rights is the Supreme Court, under its role as one of the checks and balances on the legislative and executive branch.
Very good. So let's get down to it. What are some of these laws that you say, or at least they're seemingly trying to take away people's right to vote, even if they're saying the reason is to prevent fraud and so forth? What exactly are some of the specific laws? And more importantly, this North Carolina case, let's focus in on that.
Well, largely these laws focus in, and particularly in North Carolina, they focus in on voter IDs, which most people are in favor of having voter IDs. But in the North Carolina case, they went further than other states in terms of defining what was an acceptable identification. They also went in and decided to eliminate certain forms of early voting, which is to say a lot of states these days will allow you to vote before the election, taking into consideration that a Tuesday in November may not be a day, particularly if you're poor and can't get off work, you can make it to the polls.
Or inclement weather.
Whatever it is. They also got rid of a Sunday voting day. And I'll come back to why I did all this. They got rid of same-day registration, and they also got rid of pre-registration. And pre-registration in North Carolina was if you were getting a driver's license, even though you weren't eligible to vote, you were 16 or 17, you could pre-register so that when you turned 18, you could vote.
And it was automatic. You didn't have to go through another process.
And the legislature in North Carolina got rid of all of those in one sweeping bill that was passed through the legislature and placed on the governor's desk 3 days after Shelby County came out.
Wow.
There were no hearings, no testimony. They just passed it. Now.
So consequently, no legislative history.
That's exactly correct. There's no testimony, there's no legislative history. The court seemed to find that very suspect. But what they found more interesting is that prior to that, this bill had been sitting around in the legislature for a period of time, and there have been a number of agreements made between the two parties about what the shape of a new bill would be, all of which got abrogated after Shelby County was decided. But the legislature had specifically asked for voting patterns by race. The appellate court says that the lower court's decision found that they had done very serious research about how people voted and what impacted on them. And for instance, in voting rights, they found that if you were excluded certain types of IDs, it disproportionately impacted on African Americans.
And they actually researched this.
They actually researched that. And so what they did was they excluded all of those ones that impacted on African Americans, but didn't impact on white voters. So that was one of the things that the court focused in on. They also focused in on that on absentee voters. The legislature had initially, in the initial draft, included an ID requirement for absentee voters. But whites vote disproportionately absentee. The legislature removed that requirement as they went through this. So the impact there, of course, was it allowed white voters who vote more absentee to vote without ID, but restricted the ID that African Americans could present in order to vote.
Unbelievable.
And they thought that that was an indication of intentional discrimination. Then they began to look at the next areas, the elimination of early voting, and particularly the elimination of the Sunday voting, because they found that this was a thing that traditionally African American churches, you would go to church, then there would be a gathering, and you would then go and vote. And there was a huge increase in African American voting as a result of this change. And the court found that the legislature knew this. They knew that this was primarily an African American voting pattern, and they deliberately got rid of that. Then
And of course, this is after President Obama won North Carolina.
Right. And they took that into consideration, too. They said, if this action cannot be seen within the judgment, sort of a vacuum, it has to be seen within the context of what's been going on in this state. And the fact that he had won North Carolina in 2008, and there was a substantial increase in African American voting, turning the state more purple. The legislature's decision to do this was directly targeted at reducing African American voting.
Wow.
They said pre-voting. They actually praised the trial judge for the thoroughness of his record.
Yes.
While they said he fundamentally erred in making the decision, and the reason they used fundamental error was that in order for an appellate court to overrule factual findings of a trial judge, they have to say that they fundamentally erred. It has to be more than he made a mistake. Or
Yeah,
she made
and
a
it's
mistake.
extremely rare.
It's extremely rare.
And in appellate law and appellate practice, it's taught to appellate judges, no, you just don't go willy-nilly doing this. The factual findings of the actual judge who was in the courtroom, hearing the testimony, judging the credibility of witnesses and so forth, is usually just taken as absolute truth. So for them to do that and find fundamental error was incredibly unique.
And it basically was that he made the findings that became the basis of their opinion, but didn't take it to its logical extent under current federal law. What he basically did was say, well, yeah, it will reduce a certain cultural advantage that African Americans have, but everybody still can vote. And they said, that's the wrong test. And they went through this, and I think I said this earlier, but it bears repeating. They basically said he was too busy. He was too deep into the weeds. He was too busy looking at the trees in order to see the forest. And then they go on, and they say, the next thing that they do is this pre-voting. Because African Americans are more likely to be poor in North Carolina, more likely to move as a result. They're more likely to have the their jobs change, etc. There's a lot more pre-voting. And the legislature knew this. And so they got rid of this. And then they said, and the same-day voting is the same thing. It's much more likely that an African American would do same-day voting, register and vote on the same day.
Right.
The legislature came up with an excuse during the litigation, about how that this was an expensive item for the state to bear the cost of, made no effort to really demonstrate why it was that, and the court just said, this is smoke and mirrors. It isn't real. This was, again, they knew that African Americans predominantly used this, and they got rid of it so that it would prevent African American voting. There's also a thing called provisional voting in North Carolina, where you may not have any ID, but you can provisionally vote and provide ID afterwards. They got rid of that, too. And again, they found that the legislature knew as it did this, that this was a predominant impact on African American voting. And last but not least, the court said that with regard to registering in advance when you're getting your first driver's license, this too was something that was a predominant act of African Americans. The legislature knew this because they had specifically asked for statistics on this, and the result was that they knew it would impact on African Americans, and they did it together. And then the court says, well, you're not allowed to, under current law, solely look at the history of a state prior to this. It is a factor to consider. And then when you look at what they called the smoking gun of intentional discrimination contained in the legislature's action, that they had the right, under the Constitution, to void the entire statute that was part of the statute that was under attack, which is what they did. They reversed the district court, and they voided all of those requirements. So they got rid of the voter ID requirement. They got rid of the ban on the days for voting in advance. They got rid of the ban on provisional voting. They got rid of the ban on voting same-day registration, and they got rid of the ban on registering when you go to get your driver's license before the age of 18. They voided all of those parts of the statute on the grounds that the legislature had intentionally discriminated against African American voters. They didn't think it was based on racial animus, which is to say that the legislature had concluded that blacks were inferior. They said the legislature had concluded that blacks voted Democratic, and they were trying to exclude them as a group to undercut those people from voting for Democratic candidates.
Which, again, either way is wrong.
It is.
Either way is absolutely horrendous, whether you're trying to keep African Americans from voting or you're trying to keep Democrats from voting. It's still, a complete corruption of a fundamental right.
Well, you would think in a democracy that people would be in favor of the maximum number of people voting. I mean, you've heard for years about how we'll get a 60% voter turnout of registered voters in a presidential election. It was in the 50s for a period of time. And people said that was a troubling sign for our democracy. Now, why you would want to take us back to the days where it was in the 50s from a standpoint of a democratic system as opposed to from the standpoint of gaining some electoral advantage, it seems to me that's a rejection of what this country is about.
I agree with you. And of course, in some countries, voting is mandatory.
It is.
And it's not, some dictator in a country you never heard of. It's New Zealand and Australia and other Commonwealth countries, for instance, where you must vote if you are eligible.
And the thing that is, as I said, when you asked me about why courts can void certain forms of legislation, we are the oldest democracy, modern democracy. As a result, we have a series of constitutional provisions that restrict democracy in a particular way. If you go look at Canada, for the longest period of time, they were a pure parliamentary democracy like England is.
Right.
The unwritten constitution. where the election occurs and the next day the new majority's in and they void the acts of the previous party. And there's nothing that prevents that.
Right.
And about a decade ago, Canada went to a Charter of Rights, which was a step back from democracy in some ways, because a pure democracy, whoever wins,
majority
wins.
rule.
Yeah, majority rules. To the imposition of a more rights-based system, wherein, yes, democracy rules, but there's always a limit to what you, the majority, can do. I happen to think that that's a very valuable check in the American system, and I think the Canadian decision to go in that direction proves it. It's interesting, though, on the same day, about an hour after the Court of Appeals in the Fourth Circuit issued their opinion, a district court in Wisconsin voided the Wisconsin law for essentially the same reasons.
And had that legislature actually investigated who was voting how and then eliminated?
That's not clear from the opinion because it's not as voluminous an opinion.
Right.
But basically, if you read the two opinions, he said that the district judge in the Wisconsin decision essentially went down the exact same track as the Court of Appeals in the Fourth Circuit. That one of the provisions in the Wisconsin decision was that a city was only required to have one polling place.
Oh my gosh.
So Milwaukee, which I think is a substantial place, could have one polling place.
Oh, that's ridiculous.
And that was done to suppress African American voting. Their ID requirement, let's understand, ID requirements have been upheld constitutionally. The Supreme Court has said, out of an Indiana case, that you can require ID in order to ensure the integrity of the voting process. But the Wisconsin requirements, like the North Carolina requirements, went well beyond what the Supreme Court said was permissible and went into effect to limit, and again, the district judge in Wisconsin said, this was designed particularly to limit African American voting.
Well, for instance, if the requirement was you had to have to show a passport in order to vote, that would have a very class bias to it because people who travel internationally tend to have more money and disposable income and so forth than somebody who's working for minimum wage who's probably not going to have a passport.
Which brings up the very interesting state court decision in Kansas, where the Kansas legislature and Secretary of State have said that if you cannot produce a birth certificate, even if you're federally qualified to vote, which is to say you can vote in the federal election, you cannot vote in the state election. So Kansas General Jurisdiction Court just this week struck that down on the grounds that it was intended to suppress voter turnout under the Kansas Constitution as opposed to a federal Constitution. But you can see why. I mean,
sure.
Who doesn't have a birth certificate? Most of us can, or we can afford to go.
People born at home, older people, people who lived in strife where, fires wiped out a whole city or whatever. I mean, there are many reasons you wouldn't have a birth certificate.
But the vast majority of those people were poor.
That's right.
And so
it's not going to be somebody who was born in the Presbyterian hospital down the street.
And the vast majority of those people vote Democratic, and the legislation was designed to suppress Democratic voter turnout, and the result of that was that the circuit court there said, no, you can't do it. Which, down the line, we should talk about how Kansas has begun a real serious attack on the independence of the judiciary, but that's a separate thing from this.
Well,
discussion.
We actually have one blog post on that, I believe, that you wrote 6 or 7 months ago.
Yes.
And from time to time, I post follow-up articles on that issue on our Facebook page. So if that is of interest to you or anyone out there, we have been following up that issue, and it would make for another good blog. But I think that we've come to a pretty good stopping point. It sounds like it's been a good week for democracy.
It has been.
Any final words, thoughts on these voters' rights cases?
I think we're going to see more of them.
Do you?
I think we're now in the post-Shelby County era where pre-checks are no longer in place, and that will result in the Justice Department bringing lawsuits on those cases where they think that there's been some form of discrimination. And there's a scattering of decisions, one out of Michigan on a recent Michigan statute, and of course the Fifth Circuit case on the Texas statute, which has also come out. So it's been an interesting week on
I should say.
on the issue of voting in the United States. And all of this is going to impact on voter turnout in the 100 days from now that we have a presidential election.
That's right. All the cases referred to, the complete citations will be on our website in the introduction to the blog. So if you didn't catch the name of the case or want to know more about it, we'll have links in there and links to the opinion and so forth. So people who want to go a little deeper and dig into it will have an easy time in doing so just by checking our website, the blog page of our website. Well, thank you for doing all that good research and clearly an important issue for many different sides. It would certainly be distressing if the opinion in the Fourth Circuit had gone the other way when it was clear the legislature in North Carolina had absolutely targeted and gone after African American voters. So it's been a good week.
On a final note, though,
Yes.
with more people being able to vote, the question is, will they understand that right now there is an opening on the Supreme Court, and all of these cases are headed for the Supreme Court, and
That's
that
right.
whoever appoints that person is going to have a substantial impact on those cases. So,
As well as many other important issues.
so if you're going out to vote, remember that this is going to impact on your right to vote.
That's right. Good point. Well, thank you. That was great.